Mention Revlon, and an ordinary person might think of lipstick, mascara, eyeliner, or the like. But anyone who knows much of anything about corporate mergers and acquisitions will think of the Delaware case that changed the face of corporate law, or at least put foundation on that face. The author of the Delaware Supreme Court's famous opinion in the Revlon case, Justice Andrew G.T. Moore II, explains how sparse the law governing takeovers was at the time.
We were operating very much in the dark at that time. You have to remember that was the period where you had Unical come up on a very expedited basis. And then a week later, we had the argument in Household, the poison pill case. And then Revlon came up. And in the midst of all of this, there was no federal governance, no federal guidance. The people were screaming bloody murder that the takeover business was out of hand and that it was threatening corporate America. And with all good intentions, I think, of Congress and the federal government completely kept their hands off, and it fell to Delaware to resolve a lot of these issues. And that meant ultimately the doorstep of the Delaware Supreme Court.
The 1985 Revlon litigation forced the Delaware courts to answer numerous largely unanswered questions about the duties of directors in corporate takeovers. Are shareholder rights plans, or poison pills, valid at all? In particular, is a flip-in poison pill, one that gives rights to stockholders generally but discriminates by denying those rights to takeover bidders who acquire more than a modest percentage of the company's stock? How long and for what purpose can a board leave a poison pill in place to block a hostile bid? How could directors take into account the interests of non-stockholder constituencies, as the Delaware Supreme Court's then recent Unical opinion apparently permitted? Is an all-cash tender offer for all shares ever a threat that can justify defensive actions by directors? The Unical opinion said that such actions have to be reasonable in relation to the threat posed. But what does reasonable mean? If directors pursue a sale of the company in response to a hostile bid, what are the rules? Are any deal protections, like a lockup option on key corporate assets, permissible? Can the board favor a friendly bidder over a hostile bidder? And by what standards will the courts evaluate the director's conduct in selling the company? For the rest of this video, we'll hear about how the Delaware courts answered these questions, and did so in litigation that essentially, from start to finish, lasted only a little more than 2 extremely hectic weeks. We'll be hearing mostly from the key litigators in the case, most of them interviewed by Ann Foster of Richards, Leighton and Finger, Herbert Wachtell from Wachtell, Lipton, Rosen and Katz, and his partners, Ted Mervis and Paul Rowe, representing Revlon and its directors, Mike Mitchell and Stuart Shapiro, at the time partners with Skadden, Arp, Slate, Marr, and Flom, representing Pantry Pride, A. Gilchrist Sparks III of Morris, Nichols, Arst, and Tunnell, lead Delaware counsel for Revlon and its directors, and David McBride of Young, Conaway, Stargett, and Taylor, one of the Delaware counsel for Pantry Pride. But we'll also hear from Justice Andrew G.T. Moore II, who wrote the landmark Supreme Court opinion. And last, but certainly not least, Ronald Perlman, head of Pantry Pride's controlling stockholder, MacAndrews and Forbes. And we'll start with Mr. Perlman. Who was he? What was his company? And how did he come to make a bid to acquire an iconic American company?
I think you probably know that you have a legendary status among Delaware corporate lawyers and lawyers who study Delaware corporate law, so this is a rare opportunity to get a little bit of better sense of your role in these cases and what these cases were about, so thanks. And in that regard, what aspects of your personal background do you think would be most meaningful to people who are studying these cases?
I think I am the world's most tenacious human being on the planet, and probably the most impatient, and like to get things done quickly and smartly, and very rarely reach the point of giving up. My first wife once said to me, "You kick a dead horse and tell it to get its ass up moving." And I think that one comment described me more accurately than anything else that I've ever heard about me.
Okay, so let's talk about how that character gets applied. As I understand it, your business vehicle, at least for a long time, has been MacAndrews and Forbes.
Correct.
What's the history of that company?
MacAndrews and Forbes came about through an acquisition by the first deal I ever bought called Cone Hatfield Industries, which was a retail, wholesale, and lease department jewelry operator. And it was significant in several ways. First of all, it gave me a very easily and quickly liquidatable vehicle to do the deal I wanted to do in. And to do so with the support, I was only buying 45% of that company, but to do so with the upfront support of the other shareholders and management. It was an American Stock Exchange listed company. Secondly, we operated the lease department stores in Walmart. So the day after this deal was announced in the Wall Street Journal, I got a call from Sam Walton. And he said, "Mr. Perlman, this is Mr. Sam. I'd like to talk to you about your new vehicle here that you just bought." I said, "When's a good time?" He said, "How about tomorrow morning?" I flew out to Bentonville, and from that first meeting, we developed a fabulous, fabulous relationship. And several years later, he said to me, "I know that you don't want to be in this business," probably 2 years later, "forever. When you're ready to get out, just call me. We'll take an inventory over the weekend, and I'll send you a check on Monday." And we did do that, and that's how it happened. And when we got to Revlon, Sam was still having problems getting major brands to enter the discount area in his stores. And the deal was that all the department stores where your brands would sit would throw you out if you went to Walmart's. And he called me up one day and he said, "I really need a cosmetics brand. Would you consider selling to us?" And I said, "You know what that means?" He said, "Absolutely." And I said, "Yes, we'll do it." And today they're our single largest customer. They're half of our business. And more importantly, I think once you have sort of proven yourself as a founding partner of Walmart and selling your brands to them, they treat you differently. And they're an amazing partner to begin with. But if you were early on with them, they treat you as almost family. And it's been a fabulous, fabulous relationship for each of our companies to have with Walmart. So we used Cone Hatfield to buy MacAndrews and Forbes, which was then primarily a licorice supplier to the tobacco industry and a manufacturer of chocolate to the secondary market, to the manufacturers. So we would sell chocolate to Entenmann's bakery, and we would sell chocolate to ice cream makers and the like. We had a very, very small retail business. And we ultimately sold that, and we're left just with the licorice business. And I changed the name from Cone Hatfield to MacAndrews and Forbes, and that's been the name ever since.
So what led Mr. Perlman and MacAndrews and Forbes to take on Revlon and its CEO, Michel Bergerac?
I had heard that Bergerac was thinking about taking it private. And it was sort of, around, they used to have what they called the gin rummy crowd. And it was Bergerac, it was Martin Revson, it was Ed Down, it was 2 or 3 other people. And all those people talked a lot. And they talked about Bergerac talking about taking it private. And I looked at it, and it was our perfect kind of transaction. It had many pieces. Many of the pieces I thought were much more valuable than the market was giving them credit for. And I liked the beauty business, which nobody else liked. And it became, very, very quickly obvious to me that this was a transaction that was just perfect for us. And, then we started the process.
Right. How important was the aspect of Pantry Pride with its net operating loss carryforwards? Was that part of the thinking too?
Well, we bought Pantry Pride because of its NOL. It was in 3 terrible businesses: the retail food business, the retail drugstore business, and the subpar finance business, basically, of electronic parts and components. And but I thought that we could get out of those 3 businesses pretty quickly, and then we'd be left with a vehicle with cash and a large NOL. And the NOL I thought was a valuable asset for this or any other transaction. When we sort of defined Revlon as a target, they just fit together really, really nicely, both in timing wise and in what we expected to do as a vehicle.
Mr. Perlman's scrappy Philadelphia underdog personality couldn't have contrasted more sharply with the style and reputation of Michel Bergerac, Revlon's CEO.
He probably lived the biggest life of any CEO in America, maybe even the world. I mean, their offices were like palaces. He had a 727 of his own. He traveled with his own doctor. He had his plane outfitted to go on safaris with gun racks and all the accoutrements for safaris, and was well paid, on top of it. So he liked the lifestyle.
Mr. Perlman's initial encounter with Mr. Bergerac about a possible acquisition of Revlon was apparently cordial enough, but that didn't last long.
My first meetings with him were very good.
Okay.
I called him up, we met, we had several phone conversations. He was entertaining the idea seriously. And then, like that, he changed and no longer wanted to do a transaction of any kind. Maybe he thought that he still wanted to take it private sometime later, but he certainly didn't want to do the deal with me. And he called me up one day and said, "Look, I really don't want to do that deal, and let's just stop talking." And then was unavailable for any further phone conversations or meetings.
Mr. Bergerac's disdain for Mr. Perlman was widely known.
So during the depositions, did you get any sense from the Revlon directors that they viewed your client as an upstart, someone that they didn't really want to sell to? Did that come through at all in the depositions?
Yeah, oh yeah. And I think it was Bergerac who, I think I took Bergerac's deposition. And I think I remember getting this disparaging of Pantry Pride and how Revlon was too important a company and too good a company to be taken over by the likes of a grocery store chain or something of that sort. And I guess that was pretty typical at that. Back in those days, anybody who was sort of on the hostile side of deals was considered something less than reputable just by virtue of being willing to do a hostile deal. In those days, it was still sort of poor form.
The relationship between Mr. Perlman and Mr. Bergerac, Michel Bergerac, who died last month, I think, was really, I think, what set the tone of the whole case. Bergerac and Perlman were like potassium being put in water. They could not stand each other, and they did things that were intended to thwart one another or to annoy. And one of the things that is alluded to in the opinion at the outset, we're talking about the antipathy that existed. It's based on Mr. Bergerac's testimony on his deposition. And this is what he said: "I could not believe that the great house of Revlon would be taken over by a grocery store named Pantry Pride."
Respect for the deceased, however, warrants hearing a brief acknowledgement from one of Mr. Bergerac's litigation adversaries that he wasn't all villain.
I met him later, 20 years later, in a doctor's office where he was a patient and I was a patient. And he was a charming, lovely person. I talked to the doctor's staff, and they all loved him. Said, and he was long since retired, and they say he was just one of the nicest people they'd ever dealt with. So who people are and how they behave is not always concordant.
In any event, Mr. Perlman didn't let Mr. Bergerac's resistance stand in his way. On August 19, 1985, Pantry Pride publicly announced its intentions to make a tender offer for any and all of Revlon shares at $47.50 per share. Perhaps just as unsurprisingly, Revlon promptly took two important steps to deter that offer.
Revlon started the litigation in Delaware in district court before Judge Farnham. It was essentially that our offer, which at the time I think was for $47.50, was rife with disclosure issues, including the failure to include Ronald Perlman's financial statements, which was the last thing Ronald Perlman would ever want to do, was publicize his financial statements. And there was also interesting argument about the margin rules. That was argued before Farnham in August of 1985 in federal district court. It was, as he told us, his first takeover matter. Luckily, he wrote a rather lengthy opinion denying all of the relief.
Revlon's other initial response was the adoption of a novel form of poison pill. If triggered by a bidder acquiring over 20% of Revlon stock, each share of stock would receive, flip into, a right to get a Revlon note worth $65, except that the stock owned by the bidder would get nothing. That novel feature, as well as the uncertainty about whether the Delaware Supreme Court would uphold the recent ruling in the household case, made Revlon's pill a ripe target for litigation.
You have to remember that when it was adopted, the pill was still a matter of debate in legal circles. Very, very serious and heavy debate. So when it was adopted in these contexts, before we announced the decision in household, which was, as I said, argued a week after Unical, but not decided until 7 months later. I mean, decided in the sense that we issued the opinion. The context is that people are still sort of acting sort of as guesswork in terms of their legal planning, and it was a sort of an undecided era until the poison pill was fully adjudicated. That is, we issued our opinion later. But you have to bear in mind that in every instance that we're talking about, the poison pill was not yet an approved form of defensive measure, other than Justice Walsh's opinion.
And I think the sort of status of the law with respect to the pill, the fact that the pill was so controversial and had just been approved by the court, caused some of us on the plaintiff's side in Revlon to think that the Revlon case might be a circumstance or an opportunity for the court to establish that the rights plan couldn't be abused.
But despite the remaining uncertainty about poison pills in general and the novelty of the Revlon pill, Pantry Pride's lawyers weren't overly optimistic about their lawsuit to invalidate it. But they had another reason for bringing that lawsuit.
In Chancery, your complaint, I guess, was filed on August the 22nd, and it had arguments about the poison pill and then about various other things related to breach of fiduciary duty. Which one of those did you think had the best chance of success?
Well, the pill argument looked a little more problematic after after the household decision. But the reason you're in court is to get depositions, because that's a way of communicating with the directors on the other side and creating exposure for them. And the whole theory, at least at Skadden at that point, from Joe Flom on down, so what you did with litigation was you created pressure on the other side so they would make mistakes. And he used to say that, we win because we get the other side to make mistakes, not because we're brilliant or we're better than anyone else, but we get enough pressure going, they will inevitably make mistakes. Whenever we litigated with Wachtell, that theory really was at the fore. Let's put as much pressure on as possible, see what they'll do, because inevitably they will hopefully at least give us a reason to be in front of a judge arguing they've done something wrong. And the Wachtell practice also was to make extraordinarily lengthy and detailed draft minutes, which was like having a transcript of a board meeting. So you went into a deposition with 30 pages detailing what directors had said. So we didn't always win, obviously, but that gave you at least a hope that by getting litigation going and putting the pressure on, something would come out that you could use.
Revlon's next move, on August 29, 1985, was an offer to buy up to 10 million shares of its own stock, in exchange for a package of new debt obligations and preferred stock worth about $57 per share. This move effectively blocked Pantry Pride's lower bid, but only temporarily.
In the course of the back and forth of the offers and counteroffers, Revlon initially did a self-tender, an exchange offer for notes for stock, and I don't know how much you remember about that, but was that something that gave you any pause or gave you any concern?
Well, it was very interesting because just before they did it, I was at the U.S. Open, and I sat in a box that was 2 boxes behind Bergerac's box, the Revlon box. And he had his box full of his cronies and executives, and he was eating grapes. And he started throwing the grapes at me. And fortunately I had ducked and he didn't hit me very often, but I was thinking, what's going on, that he's throwing grapes at me, and when he was taking delight that he was going to be the winner, that he just was going to announce on Monday this exchange offer, and that's the end of me, When I read it, to me, he just bought 30% of the stock or whatever it was instead of me buying it, and we'll just equalize the price out, and that's the end of it, It doesn't mean anything, And whatever conditions they put into the instrument could be waived or were of no moment. So it didn't slow us down for a second. It actually made it, he financed a third of the transaction for us, Not a third, 20% of the transaction for us. That's all he did.
As we know, Revlon's exchange offer didn't stop Pantry Pride. What it did do most significantly for the latter stage of the litigation, was create a group of holders of Revlon debt securities that were protected by covenants. Those covenants precluded Revlon from selling assets or taking on significant new debt, unless the covenants were waived by Revlon's independent directors. And sure enough, when Pantry Pride renewed the bidding after Revlon completed its exchange offer, that's exactly what Revlon's board of directors, including its independent directors, approved on October 3, 1985. A leveraged buyout by Forstmann Little with Revlon Management at $56 per share, involving sales of Revlon assets and taking on new debt. According to Pantry Pride's lawyers, this changed the atmosphere of the litigation dramatically.
October 3rd, you find out that they're doing a deal with Forstmann Little. So how did you feel about that when you heard that was who they were going with? Was it a surprise?
I don't know if it was a surprise, but it was a bid in Congress because Forstmann Little was going to have to raise a lot of debt to do the deal. And of course, Revlon's prime argument against Pantry Pride was all the debt you're assuming. And now they're going with an LBO firm, which was also going to have to raise a lot of debt. Also, one aspect of that proposal, which I always thought was critical and backfired against Revlon, was the fact that the executives were going to be participants in the LBO by exercising their parachutes. And that's not the purpose of parachutes, to buy 25% of the equity of the company that you're managing. And that's what was happening here. Apparently about $80 million of the equity was going to come from the executives, 50 million of it from Bergerac. Now, when that hit the newspapers, I mean, he was roasted in the newspapers, rightfully so, because he had said, I would never sell Revlon for less than $65. Well, he was then participating in a sale of the company to himself for $53, where the company is helping finance his acquisition. We had been subject to a lot of criticism by Revlon, and a lot of it totally unfair, especially regarding Perlman and his intentions. And Bergerac turned out not to be, he claimed not to be a master of the universe type. He was exactly a master of the universe type. Selfish, arrogant, and grubby, and willing to take whatever steps necessary to secure his control of the company. So, reaction to Forstmann Little, somewhat surprised, but we also thought it gave us an opening. Finally, now maybe we could take the high road, and the criticism leveled at us as bust-up artists would not be as strong, given Bergerac's total conflict in this situation.
It also changed the whole dynamic. As opposed to a hostile offer, we're now in an auction. So it's just a question of who's paying the highest price.
Which brings us to a bidding tactic that made this a most unusual competition.
In the course of the back and forth in this deal, after Forstmann Little entered the picture, you had an affidavit at one point where you talked about your philosophy about bidding against Forstmann Little, and the court described it as an incremental bidding strategy where whatever they could bid, you could bid at least somewhat more.
Quarter.
Quarter, right, which is what we saw, in fact, right. I think I know the answer to this, but just to hear it from you, what was the thinking more precisely behind that strategy?
Revlon would not give us any of the information, but of course Forstmann Little had the information. And Forstmann Little was a fiduciary and an agent, not a principal. So I figured, look, if it's good enough for a fiduciary agent to buy this transaction at 46 or 47 or whatever, it's got to be good for me. So they did the due diligence for us, in effect. And, we were able to get enough of a feel for the value of the assets we did not want to be in, plus the comfort that Forstmann Little agreed with us as to the value, that that we were able to make that statement. So we had a lot of confidence in the ability of Forstmann Little to do their due diligence properly.
And your work for you.
And our work for us, that is correct.
And you had NOLs that they didn't, presumably.
Correct.
And that's where things stood as of Friday, October 11th, 1985. Forstmann Little and Revlon had a signed deal at that price, and Pantry Pride had stated its intention to top any Forstmann bid by 25 cents a share. But at this point, none of the issues that the Revlon case is famous for, limits on lockups and other deal protections, the director's duty to achieve the highest value available in a sale of the company, and the obligation to consider stockholder interests to the exclusion of other constituencies in a sale of the company. None of those had come up yet at all. But just 3 weeks later, they would all have been briefed, argued, and decided in both the Court of Chancery and the Delaware Supreme Court. In the week of October 7th, the pace of litigation seemed to have picked up, with Pantry Pride pressing for discovery and scheduling a preliminary injunction hearing, and the Revlon defendants resisting those efforts.
Throughout that week, we had one conference after another with the court, with Larry attempting to fend off discovery and our side attempting to get discovery. And one of the themes that was repeated in those conferences with the court is, from Larry's side, and understandably, is this whole thing may be mooted out. There's going to be a board meeting in the near future, and there's no reason for the court to do anything. There's no reason for it to take deposition. The board hasn't made any final decision. Just wait. That argument was made on I think it was a Tuesday, a Wednesday, and a Friday of that week.
That Friday, in fact, the key individuals on the two sides, Mr. Perelman and Mr. Bergerac, were having their depositions taken, and those depositions ended in a curious fashion.
That Friday, I'm up in Providence visiting my daughter, Kathy, who's at Brown University, and I get a phone call from Steve Lamb. And Lamb says, I was just defending Perelman in the deposition, and after 10 minutes, Herb Bartel decided that Perelman was not being sincere and stopped the deposition. Not only did he stop the deposition, Bergerac was simultaneously being deposed. He ordered that deposition be stopped also.
Did someone call the judge to discuss
We didn't do it. It
consequences?
was Friday afternoon. Nobody did it. No one thought, why, what's happening here? Why is this going on? Also, that Friday, the Young Conaway firm appeared before Justice Walsh in connection with scheduling our motion for a preliminary injunction against Revlon. And nothing was done because the lawyers from the other side represented, we don't have to schedule anything for next week. Revlon may be doing something over the weekend, which will just moot the whole situation.
Well, Revlon did do something over the weekend, but it sure didn't moot the case. Faced with a 24-hour take-it-or-leave-it ultimatum, the Revlon board approved a new deal with Forstmann on Saturday, in exchange for Forstmann raising its bid to $57.25 per share, $1 more than Pantry Pride's bid. Revlon gave Forstmann some powerful protections. A $25 million fee if the deal were terminated. A no-shop agreement, promising not to pursue other bids. And, most importantly, so-called lock-up auctions to acquire two key Revlon divisions at bargain prices if Revlon were acquired by someone else. As part of the deal, Forstmann agreed to provide another benefit, one that proved to be critical to the case.
Early on, back in, I think, the end of August, early September, Revlon, as part of its steps to defeat Pantry Pride, issued 11 3/4% notes and a slice of a participating preferred stock for 10% of its outstanding shareholders. And they get 80% is tendered, and they buy 10%. But the covenants in the notes essentially prevented the company from acquiring any more debt. So what happens, though, on October 3rd, when Forstmann Little comes in? There's a whole pile of debt put on the company. And the note holders start screaming because the face value of the notes go down 10 to 15%. And by the time October 12th comes, that board meeting, some of the directors have their own independent counsel because they're so upset over what's going on. Judge Rifkin was very candid in admitting that all the stockholders were furious at the directors for what they had done, and that part of the deal on that Saturday, when Forstmann agreed to shore up the notes and make sure they traded at par, was to alleviate the concerns which the directors had over their own liability for violating the covenants in the original notes. So they were in an impossible situation at that point.
And the interesting thing is the note holders were also shareholders, many
Right.
of them, because there'd been a partial tender, right? So they were antagonizing their shareholder base as well as the note holders.
He said in his affidavit, "I and other directors believed that we had a moral obligation to attempt to restore the value of our holders' notes."
Vice Chancellor Walsh was persuaded that the Revlon directors accepted the revised Forstmann bid due to concerns of personal liability to disgruntled note holders, finding that undoubtedly support for the notes resulted in a significant financial benefit for the note holders. But at whose expense? Certainly not the board's, who used it to rid itself of a vexing and potentially damaging source of litigation. But there was another side to that story.
I think we had the right side of the motivation question. I don't think anybody really thought that there was a lawsuit against the individuals. Think about that. There might be a breach of contract claim against Revlon itself, but it was a stretch to get to the individuals in terms of that. Maybe some stockholder after the contract claim could bring a derivative claim, but that was pretty far-fetched. And the disclosure claim didn't appear to have any legs to it.
Also, the fact that at least one of the directors, Louis Glucksman, had his own lawyer in the boardroom didn't necessarily reflect concern about liability to the note holders.
Yeah, and that seemed to be of some importance to Judge Walsh, but I think the record was pretty clear on that at least it was Glucksman had his counsel there, as he apparently did any time he got involved in these takeovers, and he had his counsel there back on October 3. Before the concept of changing the notes had really come up. I think the record was pretty clear that accompaniment of counsel was not because of the notes. It was just he was going to have counsel there, personal counsel there, no matter what, throughout the process.
In fact, Revlon and its directors emphasized that Forstmann's offer to shore up the value of Revlon's recently issued notes was a key reason justifying their approval of the revised deal with Forstmann.
The fact that we were interested in doing something for the note holders was baked into the record. There could be an argument, the other side sponsored the idea that we were doing it because we were afraid of litigation, and we denied that. But there was no dispute that we thought we were doing a good thing for the note holders, and that was perfectly consistent, if not required, by our fiduciary duties.
I remembered that Herb Wachtel had made that argument. What I didn't remember, and what really stood out in looking at the case below, is he not only made the argument, but he quantified it. and he quantified it as basically another $2.25 as in the value of the offer, which basically was saying to the court, we've got one offer here at $57.25 plus $2.25. That's $59.50 versus a $56.25 offer. And then indeed, Marty Lipton advised the board that it was appropriate in the takeover context to consider the interests of other constituencies. And these note holders were another constituency. And he had all the reason to say that because of what the Supreme Court had said only months earlier in Unical. And I think that Skadden was probably just as concerned about that issue and whether and that language and how the Supreme Court would react to that. I mean, we now look and we all know what Revlon stands for, and it stands for the fact that if you're at the end of an auction, or you're in an auction, and that's the role you've taken with a sale of a company, a breakup of the company, that your only concern is got to be get the best price for stockholders. But nobody knew that at the time, and indeed the latest pronouncement by the Supreme Court pointed in the other direction.
When Unical came out, that seemed to be the apex of director discretion in fighting hostile bids. And it had huge language in it about the board's right and perhaps obligation to consider all kinds of corporate constituencies in deciding what to do in response to a takeover proposal. So while Unical is viewed today as a form of enhanced scrutiny and a restriction on director power, when it first came out, it was, I read it at least, as a huge gift to directors of a wide berth in takeover decision-making.
Revlon and its directors also emphasized that the extra value that Forstmann was offering on Friday, October 11th, however you quantify it, was only available for one day on a take-it-or-leave-it basis.
Was there ever any thought about just saying, okay, let's just say to both bidders, you have till this date, midnight on whatever date, give us your best bid, whoever does it gets the company, and that's the end of it. Is that something you ever considered?
Well, I think so, but what Forstmann said to us was, we're not playing this game, this 25-cent increase game, and we have to have our best and final negotiation and decision, and who knows whether the court at the Chancery level or the Supreme Court level believed what Forstmann told us, and who knows whether they believed that we believed what Forstmann told us. But to me, that was a critical hinge as well, because the board was acting on the assumption that Ted Forstmann was telling the truth.
Perhaps the most critical hinge for the defendants, however, was the almost surreal state of play on Friday, October 18th, when the Court of Chancery heard Pantry Pride's motion to enjoin completion of the Forstmann-Revlon merger. At that point, the Forstmann deal stood at $57.25 per share, plus whatever value you could attribute to its support for Revlon's notes. But Pantry Pride was only offering $56.25 per share.
Eventually, I decided, maybe I decided in advance, but it certainly was accentuated by the fact that I was not in a winning mode based on the judge's demeanor and questions and the like. I decided to make a very, very strong argument, and I can actually read it to you now if you want. And then I came back and see if I can find it. And then they came back to hit it again periodically. But the irony is usually, Your Honor, when people come in after the fact and say, well, here I am, I'm really prepared to do more if only the board had left the auction open. This is usually rejected by the courts who say the board has settled the deal. But usually it's rejected in the context where the disappointed suitor comes in and says, I'm willing to do better if only they left the auction open. What do we have here? They come and say, even now, we're willing to do worse. And then I hammered that theme, that they had never said they were going up, they had refused to go up, and basically they were seeking to enjoin, as I recall, Forstmann Little and go forward with the deal with an offer which was worse than the offer on the table. And there, suddenly, the judge was silent. I did not get, I don't believe I could look again, I don't think I got any kickback on that argument, and because it was sort of unanswerable. It was effectively an unanswerable argument.
I think the other side, it wasn't so important what I sensed, but I think the other side sensed that they may well not win this if they don't put a higher offer on the table, that it was going to be really hard for Judge Walsh to, in effect, facilitate what was a lower offer.
That point wasn't lost on the lawyers for Pantry Pride.
Although we were complaining about never having been given an opportunity to bid again, and we were arguing that we would have bid higher, we hadn't, in fact, made a bid. And so I had thought that when we went into the hearing that we would hear about that, certainly from the other side, and I expected we would hear about it from the judge as well, because I didn't think the judge was going to enjoin the higher deal based on our argument that if given the chance, we would have bid more.
Hadn't yet bid more. Despite Pantry Pride's avowed strategy of offering to top Forstmann's bid by 25 cents per share.
Help me out with this one.
Yes.
Because you were at 56 and a quarter versus Forstmann's 57 and a quarter for maybe a week or 10 days or so. And I'm wondering, what
Why'd
happened
we
to that
stay there?
incremental bidding strategy?
Yeah.
I mean, why not just top pretty much right away? Is there?
I don't remember what was going on at the time, but there must have been some goings on that made us sort of sit and wait until the right time. I think the timing of when we jumped was to us very important, so that it might maybe take them by a little surprise, and they wouldn't be prepared for it. And I think that's what did in fact happen.
The right time, as it turned out, was immediately after the oral argument on Friday, October 18th.
To end the story, Stu has already mentioned Howard Giddis. I sit with Howard. The argument's over. We go walking back to Skadden. On the way back to Skadden, we talk about it. We both think we got a chance to win, which, doesn't happen often, to win. And he raises the idea, maybe we should just raise the bid. So we go to an office at Skadden in Wilmington. We call into the townhouse. And of course, Ronald is there. All of his board members are there. Flom is there, of course. Drapkin is there. And we get on the speaker with them. And something had happened that we didn't know about. Every 15 minutes, they were getting phone calls from lawyers who were in the courtroom advising them of the progress of the arguments, including Pam Takalis. I don't know why I remember, but Pam was one of them. And their position was, it looked like we were going to win. And Howard raised the issue with Ronald, well, why don't we bump it up and make sure? And Perlman, has very, very good financial instincts, immediately went along with it. We agree to go to 58. I go outside and I call Bruce, and I said, Bruce, guess what? 58, get a letter to Judge Walsh.
We'll never know, of course, what would have happened if Pantry Pride hadn't raised its bid after the oral argument. But 5 days later, Justice Walsh issued his opinion granting the motion for a preliminary injunction and setting the stage for an appeal at breakneck pace.
So you get the opinion on October 23rd, and the next day the ruling is stayed pending appeal, and the interlocutory appeal gets certified by Justice Walsh.
Right.
Then on the 25th, the Delaware Supreme Court accepts the appeal. And then they set a nice briefing schedule for Stu for his return of October 28th, an answering brief October 29th, and then and simultaneous opening and simultaneous answering 28th, 29th, and oral argument October 31st. So you go all the way from opinion to oral argument, 8 days,
8 days, right.
full briefing. And let me just mention that in 1985, as we all remember, when you were printing off a brief, it printed as 1 minute per page. So you couldn't be doing drafts of the brief where you just keep casually revising it and putting it on. So that was quite some effort to get those briefs done.
It was.
Going into the highly expedited appeal, here's how Revlon's lawyers saw their best arguments.
My primary argument was that if the board hadn't acted at 5725, then the other side was going to get it at 56. It wasn't, you didn't have a choice of, so that was my argument, that this Forceman Little said, I'm not going to be a stalking horse, take it or leave it, 5725, we want the lockup. And if we hadn't acted, then the 56, and by the way, everybody had already decided that the rights plan was out the window. So they could have gone forward, but for the lockup, and taken the company at 56. We did 5725. It was rather clearly better than 56. Maybe it was 50 cents better, maybe it was 75%. But we were at the end of the process. It was pretty clear at the end of the process, and that was good.
Our initial reaction to the opinion was it seemed inconsistent with Unical, broadly read as it was at that time. And it also posed, it's immediately apparent from the way the facts were in the case and the way the doctrine was stated, it posed a real quandary for directors. Because what it seemed to say was you can give impediments or lockups or whatever you do that spur the bidding to new heights, but you can't do one that ends the bidding. Well, even then, that was a head scratcher, because, well, what does that mean? So if someone's at $50, someone else comes along and says, I'll pay you $53, but only if you give me this lockup or this stock option or this other impediment. Now you think, well, if I take the 53, if I don't take 53, I'm at 50. Well, that doesn't make any sense. Take 53. Wow, but if I take 53 on the condition on which it's offered, maybe that stops somebody else from going to 54, but maybe it doesn't. But if I don't take 53, I'm at 50. So I remember thinking, maybe not immediately, but basically what the holding in the case was, and this is what I alluded to earlier, that a board of directors has to breach its duty to do its duty. If you don't take the 53, you've clearly done the wrong thing because you leave the stockholder at 50. But if you take the 53 and that prevents somebody else from going to 54, when they put 54 on the table, they're going to win, because they're going to say, I'll only bid the 54 if the court knocks out the impediment that was associated with the 53. Seemed a little hard to justify from a purely doctrinal perspective.
I think we were also quite taken aback by the constituency point, because our whole, we were, if you will, an ideological firm, which, unlike some firms, tended to take a public position about takeovers and the board and management's ability to respond to them. And fundamentally, part of the sort of deep intellectual structure of that position was that corporations, the A.A. Burley theory of social responsibility of corporations, that it's a nexus of rights, but it's not just the stockholders and the company. And this seemed to just explode that and just say all Delaware cares about is the last dime. And
And coming so soon after Unical, which endorsed Marty Lipton's, and quoted it at length, article about the constituencies and stakeholders, and then this seemed to be pointing in the opposite direction.
At least one of Pantry Pride's lawyers, however, didn't think the argument about the note holders was a big deal either way.
And then what about the notes? Obviously Unical had just come out a few months earlier where there was the language about other
Yeah.
constituencies, and here there was something
Yeah.
to do with the notes and how they had treated the note holders. How did you think that would be received on appeal with the Supreme Court?
Well, I guess my reaction to the note holder argument had a couple of different reactions at the time. One is I thought that it gave us a little bit of it gave us an argument about director interest. It gave us an argument that could challenge the loyalty of the directors in some fashion that otherwise we didn't have too much. Although as I look in the footnote, that the Revlon board was dominated by insiders, so it looked like maybe I don't remember that part very accurately. So I thought we had a little bit of sex appeal in terms of director interest. But my recollection is that we had matched the note holder offer. In other words, we had said, we'll do the same for the note holders that Forsman Little has done. In light of that, I kind of thought, isn't it sort of moot now? I mean, who cares about the note holders? We're doing the same for the note holders. They can't use the note holders to justify the current treatment of us that we weren't willing to do for the note holders what Forsman Little was willing to do. So I was, I guess, a little surprised that the opinion went as far as it did in relying on the note holder situation, as opposed to just what I thought was sort of the more compelling argument is we're offering more money. You're selling the company for cash, any and all shares for cash, and we're offering more. I remember we cited, I think it was Wilmington Trust versus
Coulter,
yeah. And that was our big precedent, was we were saying you can't sell the company to the low bidder. And I thought that was a pretty good argument, with or without the note holder problem. So I guess I was a little surprised the note holder became such a big deal.
In fact, note holders weren't the focus of Pantry Pride's argument in the Supreme Court.
The heart of my argument was, they were having an auction. If they were afraid of losing Forsman, all they had to do was say, all right, all bidders, tomorrow by midnight, get your best bid in. We'll give lockups, no shops, put your best bid on the table. And then the pressure's on both bidders. If Forsman walks, you still have Pantry Pride, doesn't know that they're walking, so it's going to have to put its best bid in. So that's just one option of many that the board could have adopted that would not have disfavored one bidder over the other.
Going into the Supreme Court argument, it was Revlon's lawyers who were emphasizing the treatment of the note holders in the Forsman revised deal, and invoking Justice Moore's statement in Unical just a few months before that in responding to a hostile takeover bid, directors can consider the impact on constituencies other than shareholders, i.e. creditors, customers, employees, and perhaps even the community generally. But that argument failed, unexpectedly and spectacularly.
This is the one I have the clearest recollection of. I've looked at the transcript. It's not quite as crystal clear. Let me tell you how for 32 years I've thought about this. I go on and I say, and as to this other point, Your Honor, you guys just told us, 3 or 4 months ago in the Unical case, they all knew I'd been in the Unical case, so that it was okay to consider the impact on constituencies other than shareholders, including creditors. And what more ideal group of creditors could you possibly have than these creditors, some of whom, or almost all of whom, were stockholders 2 weeks ago. In fact, apparently, the presses hadn't even gotten, some of the people didn't even have their notes yet because they hadn't been mailed. So it's both. If there's ever another constituency that that you could consider, this is it, under the guise of creditors. These are almost quasi-stockholders. And Drew Moore, and the way I remember it is that Drew Moore said, well, we didn't mean that. In which case, I sort of said, well, Your Honor, if accepting that, I will move on. I can't do anything about that. If you didn't mean it, I will move on to whatever my next argument was. Now, it turns out that the way it reads in the transcript is he didn't say we didn't mean that. He said we only meant that in the context of front-end loaded two-tier tender offers. Well, that's nonsense. That's nonsense today and yesterday and whatever. They said it. What obviously they really meant was we didn't mean it in the context of the auction type process that they then proceeded to outline, and they didn't mean it in that context. But it was like somebody saying we just didn't mean it. And I look at it and say, well, what can I say to that? And I moved on.
The Revlon board argued that it acted in good faith in protecting the note holders because Unical permits consideration of other corporate constituencies. How did that go at the oral argument? I assume that was a big focus of Gil Sparks' argument, and how was that received?
Not well. There had been a lot of talk and some statutory amendments that had focused on the notion of multiple constituencies and that the board has the power to make decisions that take into consideration employees and customers and the community in which the company operates. Delaware had not changed its law and had not gone that way, and it was when Gil made that argument, Justice Moore just shot it down and basically said, you can consider other constituencies. That doesn't mean you can do it to the detriment of shareholders. They come first. That's where your primary obligation is. I wouldn't say that Gil's shoulders fell at that point, but they did in a sort of metaphorical way, because it was clear that if that argument didn't work, then the directors had a huge problem because they had favored the note holders at the expense of the shareholders. And if that wasn't permissible, then they lose.
And lose they did. The next morning, when the Supreme Court delivered a short oral ruling affirming the Court of Chancery. The Delaware Supreme Court's famously influential written opinion followed, but not until over 4 months later. And what emerged puzzled even the side that won.
I reread that opinion just the other day, and I have to confess, because I can't figure out what duty was violated. It starts off with duty of care, then it says duty of loyalty, then it ends with duty of care. And I read it mostly as a further implementation of the Unical decision, which gets cited about 13 times in it. And it wasn't quite clear to me what Justice Moore was trying to accomplish. He clearly wanted to set out some overall standards for board conduct consistent with Unical, and he was gracious enough to mention several times how household was properly decided. But I don't know exactly whether his duty of care violation meant that they didn't find out what the best bid would be, or it was something else. The duty of loyalty, as Mike pointed out earlier, is pretty clear that the directors had a liability exposure which they were seeking to eradicate by favoring one bidder over who would eradicate it over the other. And he says that in the opinion, but then he doesn't end the opinion by saying that was what the problem was. So I have to confess, I'm not quite sure what it was that he was ultimately basing his opinion on.
There didn't seem to be a strong factual basis for the proposition that the Revlon directors acted with gross negligence and thereby breached their duty of care.
I remember one thing on that subject, though. I remember it being remarked, I think it might have even found its way into an affidavit, that Judge Rifkin, who was a Revlon director, made the comment that stuck in my head that he wished there had been a video camera like this in the Revlon boardroom so he could show the tape to the court, to show the court how deliberative and conscientious the board had been.
In fact, The ambiguity about whether the Revlon directors violated their duty of care or their duty of loyalty, or both, was something the author of the opinion came to regret.
I think we should have just stayed with the duty of loyalty and without injecting issues of care, because that's what it really came down to. Bergerac set the tone. He violated the duty of loyalty immediately by saying he was not going to deal with someone he didn't personally like. And you can't do that when you decide to sell the company. And when you call in a white knight or you decide to do an LBO to thwart someone who you don't like, that's excuse me, irrelevant from the standpoint of whether or not you're meeting, it's irrelevant from the standpoint of whether or not the deal should go through at this point. It's very relevant to your performance as a fiduciary. And I think we should have stuck with that notion throughout.
But exactly what was the disloyalty? The factual uncertainty about whether the Revlon directors were truly concerned about liability to the note holders may have caused the Supreme Court to shy away from the lower court's reliance on that as the loyalty problem.
I think the Supreme Court was right to duck the motivation issue, which is the way Walsh went, and just to sort of lay it out as sort of a per se loyalty slant care violation to divert money to another constituency in an auction situation. I mean, that's really what the holding was in Revlon.
That doesn't mean that Revlon's lawyers accepted the Supreme Court's decision as correct.
You had said in your Supreme Court argument that having a sealed bid kind of auction really wasn't going to work. And I think there was also discussion about the fact that the thinking was that if the lockup wasn't given, you wouldn't be able to get the money that you got from Forsman Little. Looking back at that with hindsight, do you think there was some other way that the Revlon board could have proceeded to get more money without giving the lockup?
I really don't. If you take Forsman Little at its word, which the board had every reason to. In fact, they actually brought Forsman into the boardroom, if you remember looking at the record, Teddy Forsman, and flat out stared him in the eye and said, and tested him on this idea that he was going to walk, or he was going to he was done if he didn't get everything he asked for, including the lockup. The other side's primary argument in the Supreme Court had been just the one that your question suggests. They were arguing you should have closed this auction by having a simultaneous sealed bid arrangement. But if Forsman wasn't going to bid, that wasn't going to get you anything. So I really continue to believe that that the Forsman deal was necessary in order, frankly, to get up to the 58 that they ultimately ended up with.
I think people to this day will say, look, what should the board have done? It got a higher price, but it had to acquiesce in the bidder's conditions. Didn't have a choice. Unless you take the view that Forsman Little was all a wink and a nod, and if we would have said, no, we're not going to give you the crown jewel option, they would have said, fine, we'll give you the same price anyway. If you think that, fine. And that the only reason that the crown jewel option was there was to deter Perlman, then it's an easy case. But that's not what happened.
But when all was said and done, this story about the Revlon directors being properly motivated to get the highest sale price didn't carry the day.
If you had been sitting in the Revlon boardroom, what do you think the board should have done to get to 58?
The Revlon board was a Bergerac board, completely, and never really acted as an independent unit. And when Bergerac brought in Forstmann Little, they were sort of Bergerac's bidding partner. Had the board come to us and negotiated in good faith a transaction, we would have avoided the whole nasty process. And we would have either gotten to their price or not gotten to their price very quickly. They never did that. They never gave us the information. The board should have demanded that. A lot of members of the board, particularly Ezra Zilka, took great offense at the concept that he violated his fiduciary duty as held by the court. And I think that tainted his reputation for a long time afterward, as did other members of the board, because they really didn't do what was required of them. And, you know, that's how he won, basically. But they could have had us and 1 or 2 or 5 other people, or no other people, you know, sit down and work against the Lazard evaluation or another bid, and we either hit it or we didn't, you know, and it would have been much more productive for everybody.
They declined to share any financial information with Perlman. They wouldn't talk to Perlman. They wouldn't negotiate. You know, when Drapkin would call up Lipton or Lyman, you know, they wouldn't get a straight story. It was clearly Perlman was still the enemy, and it didn't really matter what he would pay. They weren't going to sell to him, which was consistent with what Bergerac had testified in his deposition. Yeah, that you're not going to sell to Perlman at any price, basically. Now, that was before they decided to sell the company, but still, you know, the personal animus was quite clear.
And
Vice Chancellor Walsh, in his opinion, noted that it appeared that the Revlon board wanted Forstmann Little in at all costs. And that's what their behavior showed, notwithstanding all of the debt that entailed, notwithstanding giving these absolutely illegal lockups to them, notwithstanding allowing parachutes to be exercised to buy in a portion of the new company. Forstmann Little was it. Their animus toward Revlon
Towards Pantry Pride, yeah.
toward Pantry Pride was as strong as any that I ever saw in takeovers. They just wouldn't deal with us at all. We were like second-class citizens.
I can remember sitting in Skadden's conference room that very first day thinking, I think we got a good case here. I thought it was pretty obvious that that Revlon was just determined not to sell to MacAndrews and Forbes, and I'm not exactly sure why. I do remember there being some banter about Revlon being such a wonderful company with such a high and expensive products and well-regarded, prestigious products, and how could Pantry Pride, a grocery store, take over Revlon? It was obscene. But it did seem to me right from the start they were just determined they weren't going to sell to Pantry Pride no matter what. And that's pretty much the way it played out.
The Revlon case has been consequential in ways both small and large.
Anything else about Revlon that you recall or that you'd like to explore?
Perlman's number 2 guy sent me a bottle of champagne at a restaurant a few weeks later.
So you succeed in acquiring Revlon. You had a good bit of information about it, but not everything. Were there
Right.
surprises that you encountered when you?
Only positive ones. NHL was much better than we thought, much, much better NHL. The assets were worth much, much more than we thought, the ones that we wanted to sell off. The beauty business was much more difficult to manage than I had thought. although I'm still happy we kept it and still own it. But it turned out to be a much better company than I thought it was before we got in there, and with peripheral assets, like they had a Hotel Particular in France, in Paris, which was their international headquarters, that was designed around Harold Janine's management style, because that's where Bergerac came from, of having these big management meetings where everybody had a microphone in front of their seat and could speak and answer questions and blah, blah, blah. And it was much too elegant for us. And we put it on the market to sell, and we sold it to, I believe, an Arab buyer shortly after we bought the company for about $150 million US. So there were those kind of little blueberries around that were fabulous. And the people were better than I thought also. So it turned out to be a very, very good deal for us.
Revlon also conveyed some broader lessons for those engaged in corporate mergers and acquisitions. For one thing, it endorsed the content and application of Revlon's poison pill. And, of course, it said a great deal about how boards go about selling the company.
I viewed Unical as sort of a compromise, and then Revlon would be the first opportunity the court really had to say, now how is this Unical standard going to operate in practice? Are we going to give the board sort of business judgment leeway in deciding what's reasonable, or are we going to require boards to ultimately leave it up to the stockholders when it comes down to especially if it comes down to just an all-cash offer for all shares, and it's 2 cash offers to the stockholders. But what I didn't expect was that Revlon would turn into this doctrine that when you're in Revlon land, you have to behave in a certain way, and when you're not in Revlon land, presumably you don't have to behave in this way. And it's sort of this binary universe where you're either in or you're out.
I didn't say necessarily that I was enamored with his rationale. What impressed me about the opinion was its sweeping nature, and everyone talks about the Revlon duty. The Revlon duty. Are we in a Revlon situation now? That was what I had not expected.
Going into the case, did you have any kind of premonition of how much of a landmark Revlon would represent? It's probably, by its name, the most easily recognized decision in Delaware law in the merger and acquisition field. Did you see that coming, or it was...
Not at all. Not at all. The issue that the court eventually went on and made it a landmark decision was if you were in a takeover mode, you have to treat people fairly, you have to do everything reasonably at the highest price, et cetera, et cetera. Frankly, that was being done in Revlon. Ironically, I'm going to be impolitically correct now, I think the Revlon doctrine to that effect is perfectly sound.
So did you think that we would still be talking about this decision 33 years later?
I hope so. Yes, actually, because at the time it had a huge impact. It was like Van Gorkum in the sense that it was one of those decisions that resonated and generated all sorts of writing and all sorts of discussion. It was clearly not a decision that was tied to the particular facts of that case, but it set a general rubric or a general way of dealing with what was then a very active business, which was the takeover business. So if you could get away from the preservation of the corporate entity and its policies and all that sort of abstract language that the Supreme Court used and get them in an auction mode, then the whole game changed. And Revlon essentially said that.
I mean, essentially, Moore used the fact pattern as a springboard for this whole duty when you become an auctioneer, to treat both sides fairly, and he couldn't have been clearer. And that, to me, is the basic lesson of Revlon. The board just treated one side totally unfairly, and in a way that preserved their own economic situation. That was just uncalled for on their part. And Justice Walsh and the Supreme Court had every reason, as far as I'm concerned, to deny them, their attempt to prevent Pantry Pride from going ahead.
Revlon's impact has also extended far beyond the field of mergers and acquisitions. With one brief sentence that embodied and solidified the ethos of the 1980s and beyond, the Supreme Court's opinion powerfully identified the purpose of the modern corporation as first and foremost serving the interests of the stockholders.
When the opinion came out, did you have any sense that we would still be talking about this 33 years later?
Yeah, it will be. And I mean, this comes up as recently as Senator Warren's draft bill that just became public. Where, I mean, it's all sort of an anti-Revlon. You've got to view the corporation as in this context or any other context as having literally a fiduciary obligation to other constituencies. I mean, that's what Delaware law said you didn't have unless there was a connection that you could link to the future well-being of the stockholders. But yeah, it's still an issue. It goes to the core of, in our system, of what you think the role is of a corporation. And it was an issue. It was somewhat of an issue before Revlon, but Revlon really cast the issue into the limelight, and there's still people who disagree with it. I happen to think Revlon was probably right, but I think a lot of people have overread it. Because I also think you have tremendous latitude under the business judgment rule in any other context other than an absolute sale of the company or breakup of the company, when you know that the same shareholders aren't going to continue. In all other contexts, I think you have tremendous latitude, and in some cases, and in many cases, maybe in all cases, a fiduciary responsibility to the stockholders not to alienate your workforce, alienate your community, maybe even alienate the environment, because all those things blow back at you if you don't do it right and end up hurting stockholders. So this idea that a corporation, because of a case like Revlon, I mean, it's always true that you have to follow the law, but it's also true that most of the things that I just mentioned are things that it's in the interest of the stockholders that the corporation pursue and be viewed as positively as pursuing. If for no other reason, then you're going to start getting bills like the ones that Senator Warren has put out there.
You might think of landmark Delaware cases like Unical and Household as supporting the power of a board of directors to manage the corporation for the long term. And in contrast, you might think of Revlon as a case favoring consideration of short-term stockholder gain. It's ironic, then, that Unical, the company, was bought out in 2005, 20 years after its famous litigation in Delaware. Household was sold in 2003, less than 20 years after its day in the Delaware litigation spotlight. But Revlon is still very much in business, over 30 years after its hotly contested takeover.
So as it turned out, Perlman ended up with everything, and of course it became, because he's actually a very good businessman, it became vastly more valuable in his hands, although the beauty business has never really been very successful, but the other parts of the business some of which he sold and some of which he still has, became vastly more successful.
And over 30 years later, lawyers, judges, investment bankers, and law professors still talk and write about the case, even after two of the protagonists in the case, Teddy Forstmann and Michelle Bergerac, and Justice Moore, the author of the Delaware Supreme Court opinion, have passed away.